Come on down, as they say, right?
You'll give us the time limits.
I beg your pardon? They allocated 6 to 8 minutes for opening statement.
Well, tell me if I'm running anywhere near.
I will. I've got my thing here.
Go ahead, sit down.
I'm getting
You
there.
should sit in order.
I'm getting there.
This is great.
Hi, good to see you.
Yes.
Yes.
So long. Goodness.
How's your pooch?
Good. Well, we got a new one. Because one of us, we had two, and one passed. And so.
Sorry to miss the call the other day. My son.
I missed it too. My wife was in surgery.
Oh, I'm sorry. It's more serious reason. My son was graduating from college, so I.
Well, that's good. Congratulations. Yeah, I took her this morning for her first post-op.
Good afternoon.
Things seem to be okay. It's a
I assume this mic is on, correct? Yes? Okay, good. Thank you all for coming out. I hope this will be an interesting and pleasant experience for you today. Hopefully, we won't have any rain when we get out. Let me begin by just welcoming our panel and briefly giving you a little bit of background of each, and then we'll go to opening statements from each of them. Victor Schwartz is a partner at Shook, Hardy and Bacon. Mr. Schwartz chairs the firm's public policy and practice group, which focuses on integrated litigation and public affairs. He's a lifetime member of the American Law Institute. John Fund is a national affairs columnist at National Review and a Fox News analyst. He's contributed to numerous articles in the Wall Street Journal. Roll Call has described him as the Tom Paine of modern congressional reform, the modern congressional reform movement. I'm happy to know that someone is moving in Congress.
No, they didn't say I was successful.
Okay. Seth Waxman is a partner at WilmerHale. He is a former Solicitor General of the United States and probably one of the country's most premier practitioners, appellate practitioners, particularly in the Supreme Court. And finally, Ed Whalen, who's been a longtime friend and supporter of the Federalist Society, is president of the Ethics and Public Policy Center. He writes frequently for the National Law Journals and others, and he has been described as the champion of visionaries.
Something
Visionaries
worthwhile.
in the practice of law in Washington, D.C., and I'm happy to know that the legal profession has some visionaries in it. So those are our panelists. I'm Susan Braden. I just retired from the United States Court of Federal Claims after 16 and a half years. I served there. I was appointed by President Bush, and I was named chief by President Trump. And I turned 70 years old. How did that happen?
You don't look it.
But I'm so happy to be a civilian again, and I'm very pleased to be able to contribute to the Federalist Society again in a more robust way than I was able to do on the bench. And also, I'm on the advisory board of the Washington Legal Foundation. Lynn Lammy's here, which is another great group involved in the most important issues of our democracy. In 2016, Verdict, there was an article that was written, that was published in Justicia, and it said in 2020, the American Law Institute will be 100 years old. The members of ALI from the beginning have included the elite of the legal profession. Its incorporators have included Chief Justice and former President William Howard Taft, future Chief Justice Charles Evan Hughes, former Secretary of State Eli Root, Judge and later Justice Benjamin Cardozo, and Judge Learned Hand. Few law lawyers have heard of ALI, but it's one of the most important non-governmental institutions in the United States. It is a private organization, but its members have included all justices of the Supreme Court, chief judges of the U.S. Courts of Appeals, chief justices of the highest state courts, deans of almost all the law school, numerous professors and distinguished practitioners. Its elected membership is limited to 3,000. It has been noted that during the 2013 to 2016 term alone, the United States Supreme Court has cited ALI publications in 50 separate opinions across 37 argued cases, roughly 1/6 of the total number of opinions written. 10 of these were unanimous, 1 per curiam. 19 were majorities, 12 were dissents, 4 were concurrences, and 4 were partial concurrences and partial dissents. 17 of the opinions relied on more than one ALI publication. In total, there were 71 citations to ALI publications during these terms. Justice Scalia, however, has been a frequent author of opinions citing ALI publications in 9 opinions, followed by Justice Thomas with 8, Justice Alito and Justice Kagan with 6 each. Each of these 9 justices went on to write at least 4 opinions critiquing ALI publications. So we begin with Victor. Victor, you have been a life member of the ALI. Tell us a little bit about the history, why you have joined, and your
May I use this
perspectives.
thing?
Sure, absolutely. If you don't mind, I'm going to sit here.
Ladies and gentlemen, is this working? All right. Yeah, when you're my height, you don't know whether to sit or stand. It doesn't make any difference, really. Thank you all for coming today, and to the Federalist Society and Dean Ritter for having a program on this. I was trying to find a quote that described the ALI, and a good person to look to is Churchill. He always had great quotes, and he once spoke of a riddle wrapped in a mystery inside an enigma. I said, gee, that's the ALI. I hadn't really thought about it. It is the most powerful legal organization in the United States. The judge gave you some examples. The way a rabbi looks at a Torah or a Methodist minister looks at the Bible, judges look to restatements. They don't question them, most of them. They look at it and they say it's the law. 1923, when ALI was founded, its purpose, as I understand it, was to help clarify the law. When we had colonies that became states, every state had a reception statute. A lot of brilliant people here, so you probably know about them. And they took the law of England as of that date. But then there was a diaspora. So New York called the battery one thing, Pennsylvania called it another, and then men got together and said, we got to do something about this mess. And I talk lay language, forgive me. So why don't we have an organization that looks at case law, and we're going to restate it. Now, it doesn't have to be the majority view, but it's got to be existing case law somewhere. And then let's do it simple. All of you in this room have read judicial opinions. They run 30 or 40 pages. And the simplest thing, judges feel that they have to write a lot. And restatements are they're very short. Like battery, for years, was a harmful or offensive contact. That's pretty short, right? Like me. And you can understand it. They really had the most influence in tort law. And after about 20 or 30 years after a restatement is out, they do it again because there's been more changes in the law. They appoint as reporters only professors, but there is supposed to be a check and balance in that. The professors have advisors who are often people in this room, sometimes judges. And I may be wrong. Miss Middleton, the deputy director, is here, and she can correct me either now or later. But it seems like a third of them are judges. Everybody, even some who are not judges, say, call me judge. I mean, it's kind of that kind of place. And people use a lot of big words there, but it's very polite. ALI gave me a gift. I learned more ways to call somebody a son of a bitch without using those words at ALI. So the learned gentleman, that means SOB. The power of the restatements is that judges are busy. I clerk for a judge, and he would say, Victor, what does the restatement say about that? And I would bring in this book, and he would go to it. In recent years, some restatements, in some parts, some believe, do not restate existing law. For example, in the Restatement of Torts Third, there was a provision that said you had a duty of reasonable care to a trespasser. Trespasser, except for flagrant trespassers. And they never defined that. There was not one case in the United States of America that said that. And Tiger Joyce is here, the head of the American Tort Reform Association, and he led an effort where 23 states blocked that restatement. That had never been done, ever. But it was very easily to persuade a state legislature to keep its current rules on trespasser. And they usually mean you refrain from willful or wanton conduct. The definition of battery in a current restatement, at least in my view, is not in accord with 300 years of law. a harmful or offensive contact. Offensive meant offensive to a reasonable person. If somebody pulled a plate away from you and mentioned your race, that's offensive. But in this restatement, they use subjective words. So if you feel that you are going to not want a certain type of touching, you say that to someone, and in some situations, you may end up, if you violate that person's wish, don't touch me with a feather, yikes, with a claim for battery. I feel like I'm back in school teaching. But that isn't a good idea, and they've tried to narrow it, make it a little bit better, but it's still there. It's still there. And in a workplace setting, if somebody has a battery that doesn't fit within the worker compensation coverage, they can sue their employer. And there's a lot of ripple effect from this stuff. Currently, they have under consideration a restatement of consumer contracts. Now, lawyers in this room, has anyone ever heard of a separate field of law for consumer contracts? Or consumer property? Or consumer torts? There isn't any. So once you're off on that path, you don't know quite where you're going to go. And at the last meeting, there was a discussion that went 4 hours, and it got muddled down in Section 2, and I don't know what they're going to do with it. But let me mention in closing an alternative that the ALI has. In 1994, they developed a new vehicle. It's called Principles Projects. There was just one that came out on data privacy that is superb. I think everyone should see it. Principles of Data Privacy. It is a very helpful work. Principles projects are dedicated mainly to legislatures and policymakers, but also courts. But there, the reporter can be aspirational. He or she can put in some of his or her dreams. There's a correction, but they don't have to have existing case law. So at least in my judgment, when they're going off on a path where there is not a lot of case law, it's newly being formed, there's a place for it. There's a place for everything. Overall, I conclude by saying the ALI has been very good to me. It's where I met Dean Wade. There would be no Prosser, Wade, and Schwartz. I was an idiot, but I fooled him and got on the casebook. With that, I close with one thing. You become a life member if you're there 25 years. So these people, they all line up, and they were all, because I was admitted at 32, they were all much older than I was, and they're telling about their career, and then I did this, all that, or Bill Clinton is not a member. Look, this is what I did. I want to say it right now. So the...
That's pretty good.
Of course it is. It's the same. It's the real thing. So they line up all these geezers, and I'm there, and I'm the last one. And because the person who nominated me was head of the IRS, they had to admit me. I mean, it was just crazy. So I said, 25 years ago, ALI really bridged its rule about people being 35 or more to be a member. I said, ALI learns from its experience. They never did that again, and they didn't. Thank you very much.
John, would you tell us a little bit of why you have been interested in the American Alliance to do its work and your observations about some of the current projects?
Well, I agree with Victor that the ALI is extremely important and almost completely unknown to the general public. That's a natural subject for a journalist because we like to delve into institutions that exercise influence and are not well known. But I will also echo Victor in saying the ALI has done an awful lot of good, whether it's contract law, data privacy, consumer contracts, copyright law. Its restatements and its careful scholarship have been a blessing to the law. But a few years ago, I used to be deputy op-ed editor at the Wall Street Journal. A few years ago, some of our most valued contributors would come to us or drop by the office, and one of the things they would talk about is the ALI's drift, the ALI's drift. The society that we live in can be judged by the strength of its institutions. America is a great country in large part because it has institutions that have exercised great care and integrity in their practices, and great fastidiousness in their scholarship, and great objectivity where that was needed. And the ALI, throughout its history, has more or less demonstrated that. But the late Ron Rotunda, who was a professor of law at Chapman University and a longtime member of the ALI, just to cite one example, became very concerned that the ALI was falling victim to what economists call public choice theory. And at the heart of public choice theory is that institutions are driven by the incentives of their members, and the incentives of their members over time, unless they are checked, regulated, analyzed, critiqued, and if necessary, curbed, the incentives can result in bureaucratic turf grabbing. And that, I think, is what's happened in part with the ALI. Ron's specific objection came in about 2016 when the ALI drafted a model penal code, a new model penal code. And one of the things that was proposed was that affirmative consent become the centerpiece regarding sexual relations. Ultimately, this move was stymied, but it, I think, revealed some of this bureaucratic turf grabbing by people who, shall we say, had more than an objective understanding of the law. As the Washington Examiner wrote in 2016, the accused would have to prove that they had received communicated willingness. That's in quotes. This would mean that any time someone engaged in sexual activity, they would not only have to make sure they obtained the specific form of consent, but also proof of this consent. Does that sound an awful lot like the kangaroo courts that have populated all over the country in our nation's universities, to which Education Secretary Betsy DeVos had to issue a report that frankly received an awful lot of support from good and fair-minded liberals, because the situation regarding due process and fair trials, which we would expect in our legal courts, was clearly not being sustained in university proceedings. Obviously, the obligation is different. Universities have their own internal disciplinary activities and procedures, but we like to think that due process is something we observe in all of society. And then, of course, there are the other problems that Victor and Ed are going to bring up. My point here is simply this. Since the 1960s, we have seen almost every institution in this country broaden its participation, and that's a good thing. More women, more minorities, more people of diverse views becoming involved, ascending to higher and higher positions, all of this to the good. But some people have taken advantage of this and brought subjective analysis. I mentioned the penal code. We can mention the other areas of the law. They're not content with the law as it is. They're aspirational. They wish the law to be something else down the road. And it's not just Justice Scalia who expressed concern about this. You will hear this quietly from many judges around the country, many of whom used to cite the ALI's restatements more frequently than they do now. So my interest in this came, frankly, from people whom I respect and who have had a long time knowledge of the law and have written frequently about the law, who themselves perhaps were a little uncomfortable in going public with this. Professor Rotunda being an exception to that, but Professor Macy at Yale Law School and others have done that. But the majority of the people I've spoken with for my articles have made it very clear they don't want to be quoted. They've made it very clear they don't want to be viewed as dissidents within the club or people who are complainers. So to the extent that I am outside the legal profession, I only play a lawyer on TV, I look at this with the eyes of someone in the larger society. And while I'm not a student of the law, I recognize that there are problems that the ALI is bringing to the law that are unnecessary. Of all institutions in the law, we have seen many, many come under buffeting and turbulence and pressure to change, to adapt. I'm not opposed to all of that, but the ALI should be the last to change because it's supposed to state what the law is, period. End of statement. And I fear that that has been challenged. So it should continue its good work. It should also listen to outside critics that question and want more transparency and want to know exactly how these restatements now are made. Who has the time and energy to devote to them? Is it mostly academics with a theory to grind? Or is there enough participation from regulators, business groups, outside parties, average citizens, government officials? Is there enough input from them? I don't want to reach the point where if we don't ask these questions and we don't get satisfactory answers, we reach the point that the author of The Incredible Bread Machine, which is a wonderful parable written about the misuse of antitrust policy. It's in the form of a poem. And basically it's the story of someone who invents a machine that can bake bread for a penny a loaf. And in this fable or parable, he is very popular at first, but then the bread trust decides he's unfair competition. People decide that they're being forced out of business. Many people have complaints. The government thinks he's in collusion with others. They drag him into court, and he's finally sentenced. And just before he's led away, and Bill Gates, by the way, printed 75,000 copies of this to distribute to every Microsoft employee when the Justice Department went after him in the 1990s. Just before he's sentenced and sent away, he asked the judge, "May I ask a question?" And the judge sneeringly says, "Yes, you may ask a question." And he says, "Why is this happening to me?" And she looks down upon him and says, "The rule of law in complex times has proved itself deficient. We now much prefer the rule of men. It's vastly more efficient. We're not anywhere near close to that. I just want to make sure we don't even get within hailing distance of that." Thank you.
Thank you, John. How did you work? You worked sex into that. That was pretty interesting.
Had to keep the audience awake
I
somehow.
would say. Seth, I know you've been a longtime active member of ALI. Would you share your perspective during your term? Do you see anything new, anything to be concerned about in terms of the work of the ALI?
Well, thank you. I was just asking Ed, look, are you going to stand up too? Because, I'll
It's free
stand up,
choice.
but
Free choice.
we've agreed that if I sit down, he'll sit down. So I'm just going to sit here. I want to thank Dean for inviting me to participate in this panel. He was reminding me that it's now been a couple of years since I've actually been able to participate, but I very much enjoy the invitations and the dialogue that comes about here. And I think the question, as a, longtime member, I am not a life member. Although I am old enough, I was not recognized as early as Brother Schwartz here was. And so I'm far from being a life member, but I am a member of the Council of the ALI, which is one of the governing bodies. And I'll explain a little bit about the restatement process, but the first body outside for restatement or other projects outside the reporters, the advisors, and the members' consultative groups to actually look at drafts of restatements and other projects in process. And I've been a member of the council, I think, for 4 or 5 years. I think it may be useful just to explain to people in the audience where there's been a lot of talk about, what a mysterious and misunderstood organization this is, just to talk about what the actual work product is of the ALI and what the process is for producing that work product. I will say that for people who have a greater interest in this than between 12:30 and 2 o'clock today, the ALI's website is very informative about what it is and what it does and how its process works. And so I'm not going to cover all of it. But basically, the ALI, which was created in 1923, produces 3 different kinds of written publications. There are the restatements that have been discussed by the earlier speakers and that I think we'll be getting into and I'll be addressing, principally in my remarks today. And according to the ALI's style manual, the restatements aim to provide clear descriptions of the common law, the body of rules established through decades of court decisions, and reflect the law as it currently stands or might be appropriately stated by a court. The ALI also produces by itself and in conjunction with other law institutions, model and uniform codes. Everybody here is aware of the Uniform Commercial Code, which has been adopted in all 50 states and is the subject of ongoing revisions by the ALI. And the Model Penal Code, which I think it was John who mentioned the particular provision that got him and me and many other people who saw the very initial draft produced of that section by the reporters and the advisors, but is an ongoing effort to sort of revise it and make suggestions that legislatures are considered. Now, restatements are designed to be directed to courts. I've never run across a judge who simply says, you know, I'm a judge in the state of X, but when I try to find what the law of the state of X is, I just read the restatement. And, you know, that would actually not be a responsible way of judging. And there's no doubt that when the ALI restates general principles of the common law, it doesn't and it can't reflect the individual variation of different states. And the comments and reporters' notes to the black letter of restatements indicate that. I mean, no responsible judge would simply take the black letter of the restatement, not read the comments, not read his or her own state law and say, well, you know, I'm just doing this. Now, in the case that Justice Scalia dissented in, Nebraska versus Kansas, Justice Thomas, who wrote the principal concurrence and dissent, accused the majority opinion written by Justice Kagan as doing just that. And Justice Thomas, in his dissent, pointed out why the provision at issue that was invoked by the majority in that case, which is Section 39 of the Restatement Third of Restitution and this, that, or the other thing, was not actually implicated by the black letter law and therefore shouldn't have been relied on by the majority. But so restatements are written in descriptive terms and they are addressed to judges in an effort to be helpful in summarizing and restating the common law as it is evolving. There is, the Model Penal Code is directed at legislatures, state legislatures. And then there are, Victor mentioned the so-called principles of the law, and principles are primarily addressed at legislatures, administrative agencies, and private actors. Sometimes when an area of the law is so new that there's little established law in the subject, they are consulted by legislatures. But they are reserved for, and they were an innovation to take account of new areas of the law that were genuinely emerging and as to which there was insufficient established common law to be able to restate. And some examples are the principles regarding software contracts, transnational insolvency, corporate governance, which was done a couple of decades ago and is now being revised in the form of a restatement because there now is a very mature body of law on corporate governance, and transnational intellectual property. And whether a project is ultimately deemed to be worthy of a restatement or more properly characterized as principles is something that, like the warp and woof of what's being proposed by the reporters and the advisors, first to the council and then to the general membership, is also up for debate. And there have been projects that have started out as restatements that have ended up as principles and vice versa. The process is frankly what encouraged me to participate actively in the ALI. I am trying to be a good spouse and dad and leave room in my life for my family and other things that I'm passionate about, and also work full-time as a private practitioner of the law and teacher of the law. And so I only belong to a few, very few legal-related organizations, the Supreme Court Institute, the ALI, and previously some specific committees on the ABA. I am I feel like it's a very worthwhile experience to be involved in ALI because of the ALI process. The process is, as Victor says, unfailingly painstaking, deliberative. It is the model of civility. Whether Victor is true that he's found more ways to call somebody a son of a bitch, I think may reflect more about his personality than the actual debates. But I really, we can all bemoan what has happened to civil discourse in this country among people with different views. And the inability, you only have to look up on Capitol Hill to, or dueling family debates about which television news they watch and refuse to watch. It's almost like, the joke about this. I'm Jewish, so I can tell this joke. There's a Jewish guy who's stranded on some tropical island, and after 20 years, he's discovered by some ship, and he's built 3 buildings on the island. One is his hut, and the other 2 are synagogues. And they said, you're here all by yourself. You've been here for 20 years. Why do you have 2 synagogues? He says, that's the one I belong to, and that's the one I'd never set foot in. The ALI is one of these institutions which has a very, very diverse membership, not only in terms of background and a division between judges, scholars, and practitioners, but also, across the spectrum of views about what the substantive law is and should be and what direction it's moving and not moving. And these projects, it is not unusual for these projects between drafts of different sections that the reporter with the advisors and the consultative groups propose to the council and then go back down because the council questions it, as happened with the affirmative consent provision, and then bounce back and forth, come up to the membership, and then get bounced back, as I think John was mentioning, or maybe it was Victor mentioning, about the proposed restatement of the law of consumer contracts. But this iterative, deliberative process can easily take 10 years. And, 10 years, the very, very controversial restatement of the law of liability insurance was a real revelation for me, because I came to the ALI Council. I've spent a good deal of my life representing insurance companies. Sometimes I represent policyholders, but mostly I'm representing insurers. I had no idea that this was going to be some lightning rod issue, but I literally could not go to a single council meeting in which we were not spending hours going over one provision or another of what this restatement should or should not say. And, I will say that many of the criticisms that I've read, including criticism by some of my co-panel members, are directed at early drafts, not final versions of what ultimately emerges. And I have no doubt that, like any institution comprised of human beings, or indeed any being or natural or incorporeal other than the divinity itself, is flawed. And there are provisions in restatements and other publications that turn out to either be an inaccurate predictor of where the common law is moving, or a model code provision that most jurisdictions will not adopt. But this is, I think, a process that is very, very faithful to what the original intent was. And I'd like to address that, because the premise of this panel is whether the ALI has strayed, I think Victor said, in recent years from its original model. I was very fortunate to count Nino Scalia as a dear friend of mine for a good deal of my professional life. It's certainly fair to say that he and I disagreed about more things than we could count. I think, with respect, the short concurring and dissenting opinion in Nebraska versus Kansas paints an overly, and like much of the commentary that has followed from it paints a very overly simplistic view of what the ALI process is. If you go back, if you go back to the original Certificate of Incorporation, that document that was signed in 1923 by some of the personages that Judge Braden, R-E-T, cited, it says that the mission of this organization is going to be, quote, to promote the clarification and simplification of the law and its better adaptation to social needs, to secure the administration of justice and encourage and carry on scholarly and scientific work. At the founding, there was a difference of opinion among the incorporators about whether the purpose of the institute was going to be to simply discern and describe the existing state of law, as difficult as that was even in those simpler times, or to do something more. And it's reflected in the original the original statements. Under the first two directors in the very early years of the restatement, when the restatement first of contracts towards trusts and I think real property were being promulgated, those restatements did, in this balance between should we be simply stating what the law is, or should we be stating what we think, taking into account a variety of things the law is trending toward, hewed much more to the former. It was much more often than not trying to hew closely to the law as it then existed in case law, of course with clarification and simplification and synthesis that's reflected in the term restatement. But as the second director, Judge Herbert Goodrich, pointed out in the 1940s in a public statement, quote, over and over again, the statement was made that we were endeavoring to state the law as it was, not as some of us would like it to be. All the time, we recognized that there were places for a give and take, even with that limitation. In cases of division of opinion, a choice had to be made, and naturally, we chose the view that we thought was right. Now, that sentiment, which informs even the very earliest restatements, was, essentially became advanced in the several decades of the restatement in the 1950s, 60s, and 70s, and early 80s under Herbert Wechsler, who was probably the best-known director of the Institute. Wechsler advanced the position that restatements should state the, quote, better rule, even if it differed from the majority rule on an issue. The Institute, he said, in determining the law to restate, quote, should feel obliged in our deliberations to give weight to all of the considerations that courts, under a proper view of the judicial function, deem it right to weigh in theirs. And there were very notable examples in the 1960s of specific provisions in the restatement seconds that were decried as, I'll just give you a quote from a criticism that Professor Keyes of Pepperdine University made in the early 1980s about Section 402A of the Restatement Second of Torts, which I am old enough to remember was incredibly controversial when I was in law school. It was the provision that quote, restated the law of strict products liability. Professor Keyes said that this was, quote, mere prophecy and not a restatement of this law, an unprecedented departure from ALI's traditional role. Just to pick another example, the Restatement Third of Trusts announced the so-called prudent investor rule, which was not reflected in a majority of jurisdictions, which basically held that trustees of eleemosynary institutions and fiduciaries generally, 1 minute, wow, okay, you should determine whether a investment by investment was prudent. And so you've got these corpuses of money, accumulations of money invested in bonds and utility stocks and stuff. The prudent investor rule basically said that the prudence of a fiduciary in exercising investment responsibilities should be to look at the portfolio as a whole, to take account of the balance of the portfolio, et cetera, et cetera. And although it was attacked as not reflecting the law as it existed, within really a very few years became, in fact, not only the majority rule, but the uniform rule in jurisdictions in this country. I mentioned Professor Keyes, who is the only source that Justice Scalia cited in his opinion in which he says things have gone off the rails. That volume of the Pepperdine Law Review not only contains Professor Keyes' assertion that the ALI has lost its way, but a responding article by Dean Wade, who Victor mentioned was at the time the dean of Vanderbilt Law School. I see one of its faculty members here, and who was a reporter on the restatement section, second of torts. And he acknowledged that the ALI had, in the restatement second era, beginning after the war, had, quote, somewhat more frequently adopted minority positions, which he thought was appropriate, and that concerns like Professor Keyes were misplaced so long as when the restatement adopted a minority position, he said, quote, it is clearly identified and explained in the comments. And an innovation in the restatement second, which has been followed up in the restatement third, is that there is not only the so-called black letter of restating what the law is, but a lengthy comment section, which is also voted on by the membership of the ALI, that explains, among many other things, where the ALI is, quote, restating law that reflects a minority view. There are four considerations that the reporters, the advisors, the counsel, and the membership are meant to take into account in deciding what law to articulate as a restatement. And I promise, Susan, this is my last point. It's in what's called the style manual, which is publicly available on the website, and which is the ALI's long-standing articulation of what its projects are meant to do. And it says, the restatement process contains four elements. The first is to ascertain the nature of the majority rule. If most courts faced with an issue have resolved it in a particular way, that is obviously important to the inquiry. The second step is to ascertain trends in the law. If 30 jurisdictions have gone one way, but the 20 jurisdictions to look at the issue most recently went the other way, or refined their prior adherence to the majority rule, that is obviously important as well. Perhaps the majority rule is now regarded as outmoded or undesirable. If restatements were not to pay attention to trends, the ALI would be a roadblock to change rather than a law reform organization. The third step is to identify what specific rule fits best within the broader body of law and therefore leads to more coherence in the law. And the fourth is to ascertain the relative desirability of competing rules. Here, social science evidence and empirical analysis can be helpful. The debate about the balance between simply describing the sort of existing array of case law and including some prescriptive nature is one that has existed since the outset. It, as is demonstrated by this panel, is still alive and well today. It is the subject of virtually every council meeting that I have adopted in connection with one provision or another that people are having problems with. And it's a process that ought to be discussed by groups like the Federalist Society and other members of lawyer organizations, judges organizations, scholarly organizations, and for that reason, I really appreciate the opportunity to talk more than my allotted 8 minutes.
As a segue, we've not talked about the precise language that was used by the late Justice Scalia in Kansas versus Nebraska, but let me read it to you, and that'll segue into our last panelist. He noted that modern restatements are of questionable value and must be used with caution because the restatement's authors have abandoned the mission of describing the law and have chosen instead to set forth their aspirations for what the law ought to be. Justice Scalia argued that such novel views of the law should have no more weight regarding what the law ought to be than the recommendations of any respected lawyer or scholar. No longer can one assume that a restatement provision describes rather than revises the current law. Our last panelist was a law clerk to the justice, but this concurrence happened after your time.
Well after.
So perhaps you can shed some light about his thoughts and yours in this topic.
Well, thank you, Judge. Let me start off by expressing my own deep admiration for much of the work that the American Law Institute has accomplished, for the value of the restatements, and for the contributions that folks like Seth and Victor and other outstanding attorneys make towards ALI's work. Like any institution, ALI has its vulnerabilities and weaknesses, and I'm going to give a case study that I think goes far beyond anything that Justice Scalia criticized in his opinion 4 years ago, to show just how badly off the rails things can go. I don't mean to present this as typical, but I think we can perhaps ponder some of the intrinsic vulnerabilities, weaknesses that ALI has, and learn something from this example. Again, I think this is a case study of ALI at its worst. There's a 400-page draft restatement of the law on children and the law. I have not read all 400 pages. I doubt that many members have. I'm going to focus on a 30-page section, 35 pages or so, titled Medical Decisions Affecting Reproductive Health. Now, it turns out that this section never actually defines what the term reproductive health means, and that it's predominantly about access of minors to abortion, which is a rather strange undertaking for a group that's purporting to restate what the common law is, since the topic of minors' access to abortion is a topic that the states have addressed predominantly, if not exclusively, via statutes enacted in the aftermath of Roe versus Wade. So there's no need for, and I think no sense in, a restatement-style effort to try to codify what the various states have in their different ways already codified. But if that exercise, for some reason, had to be carried out, the obvious way to do it would be to present the statutory texts from different states, compare and contrast them, and discuss how judges have interpreted them. Instead, the authors of this section take a confusing backwards approach in which they purport to define some governing principle that is divorced from and contradicted by statutes in the majority of states. Let me give you some illustrations. Their black letter statement of law asserts that a mature minor is authorized to provide legally sufficient consent to abortion without notification of the minor's parent. But this statement nowhere sets forth a process to determine whether a minor is mature or not. It instead asserts in a comment that a minor is functionally presumed to be mature for the purpose of consenting to reproductive health treatments. Now, what the authors struggle to get around is that most states require either parental consent or parental notification for a minor to get an abortion, subject to a judicial bypass option in which the minor can show that she's sufficiently mature to be excused from the requirement. The default rule in the majority of states, in other words, the functional starting place, so to speak, is that a minor is not mature enough to get an abortion without parental involvement. But the entire restatement seems designed to obscure that reality. Another example, in an official comment titled Constitutional Background and Rationale, the authors present a rambling discussion of supposed constitutional doctrine. To the authors, parents are little more than, quote, obstacles to a minor's getting an abortion. Never mind that the controlling joint opinion in Planned Parenthood versus Casey explained that parental notification or consent requirements, as well as the court's judgment that they're constitutionally permissible, quote, are based on the quite reasonable assumption that minors will benefit from consultation with their parents and that children will often not realize that their parents have their best interests at heart. A third illustration. For minors who are not mature, the black letter statement says that the abortion should be allowed without involvement of the parents if that is in the minor's best interest. In an official comment supposedly elucidating that proposition, the authors assert that, quote, the immature minor's voluntary decision to terminate the pregnancy, together with clear opposition to involving her parents, indicates that termination is in her best interest and that parents should not be consulted, close quote. No citation to any judges anywhere who have ever said that. No discussion of is this a minority rule or majority rule. Now, it's even more clear from the reporter's notes, which aren't officially endorsed by the ALI membership when it votes, that the authors strongly oppose statutes that seek to ensure the involvement of parents in a daughter's decision whether or not to have an abortion. They're, of course, entitled to their own policy views on this, but their presentation of the issue in the draft restatement is deeply biased and deceptive. Yet another sign that the author's backward approach is a complete flop. They arbitrarily exclude from their concept of medical treatment affecting reproductive health various matters on which their abortion-centered rule doesn't deliver the policy results they favor. So they say sterilization, egg donation, somehow these are not issues that involve medical treatment affecting reproductive health. Why such a failure? Well, I think first of all, we're dealing here in an ideologically charged area, a very intense issue, but in an area of family law and abortion in which legal academics are heavily homogeneous. Now, I haven't tried to run through the resumes of all the different people who are involved in this process, but if you're looking to get family law scholars to contribute to something like this, you're not going to have a whole lot of diversity on an issue like this. It's simply not going to happen. There is also an utter failure throughout these 30 pages to be careful and transparent about the competing purposes of the restatements. As Seth mentioned, the restatement is now acknowledges that there's a central tension between the impulse to recapitulate the law as it presently exists and the impulse to reformulate it. We can debate whether Justice Scalia was wrong in thinking that there had been some sort of trend towards the latter more recently, but it sure would be good to be clear and transparent about what you are doing and not be doing the second, reformulating while pretending to be the first. I think we also see here an instance of mission creep. Again, why is a restatement even being done in this area? An area that at least when it comes to the central issue of minors' access to abortion, is already affected in statutes, not in common law, and has no need to be restated as though it were in common law. And I think fourth here we see just an excessive delegation. I obviously don't know the particulars of what's happened with this process, but it's easy to see that you had some expert academics who decided to run with this. You have this council in which Seth sits that by the ALI's bylaws consists of, I believe, 42 to 65 members. Well, anyone understanding group dynamics will tell you that a group that size is not going to function as a board. Now, it can function effectively through delegating different tasks to subcommittees or having different people take different roles on. Again, I have no doubt that lots of people on that committee, on that council, work very, very hard. But I wonder how many people on that committee read any part of this 30-page discussion. I wonder how many of them read through the 400-page restatement. And then you had this member vote a few weeks ago, members come to Washington, D.C. for various reasons. They have meetings with Supreme Court justices and interesting dinners, and obviously the ability to have exchanges with each other. At this last meeting, I believe there were 9 different restatements or principles that were voted on by members. Now, maybe they weren't all 400 pages long, but how many of those members who cast their votes do you think actually study these matters carefully? Perhaps Seth has some insights on that. I don't profess to know. In any event, I'm not presenting this as an indictment of ALI generally. Again, I understand that there are folks within ALI who understand that there are occasionally problems and are working to resolve that through different means. I'm simply presenting this as a case study in how things sometimes do go really poorly. Thank you.
Judge, would you mind if I just made a couple of comments while these
I was
comments are
going to
fresh in
suggest
mind?
that, but I wanted to take a point of privilege to talk about a different example that I'm familiar with, and I'll be briefer. I worked on 2 restatements. One was on unjust enrichment, which was not controversial. The one I'm on now is on the restatement of copyright law. And from the meetings, it has really broken down into 2 camps, primarily driven by academics. One is Justice Ginsburg's daughter, who teaches copyright and other things. I think she's at NYU or Columbia, one of the 2. I can't remember. And her view seems to be that this is a statutory area and there's not much need for restatement. Paula Samuelson from UCLA Berkeley has been involved very much with the software area of the law. And there's a group there that basically seems to be trying to put into restatement what is kind of really evolving law in the software area with copyright. In fact, there's a case I think the Supreme Court is considering cert in now for next term on the issue of fair use. So both sides really have a point to make. Now, there have been added a number of people from industry. This last meeting we had, a lot of people from music. I think there was recording community, traditional copyright people who are now being involved in the process. I think it's been a very interesting and high-level discussion, but it wouldn't surprise me to see that this may wind up being a restatement of copyright in the traditional industry areas and perhaps the principles in the software area. I don't know, but I'm just kind of guessing that may be where this goes, which might be a good compromise, because grafting the 2 of them together into a restatement doesn't seem to exactly fit. They both have good points. So that's just another example, though, in a more traditional area of law where you see some of the dynamics that I think that were just discussed. Now,
Yeah,
I did better. Now it's your turn.
Well, since yours is the freshest in mine, and it's actually something that I am wrestling with myself. I mean, among the, to Ed's point, I consider myself to be, an average to middling involved ALI council member. I don't profess to read every single page of commentary and reporter's notes on every single thing being addressed, but the different sections that are coming up for council approval, I do try to read, and very often, and this is certainly true in the copyright area, one thing that council members do, and I think do very faithfully, is leave their clients at the door. This is an area that's been particularly challenging for me because I represent a lot of content providers, like Disney and Fox and Warner Brothers, but I also represent the people who think that copyright laws aren't strong enough, but I also represent Google and Apple and Verizon and other people who think that the copyright laws have long outlived their usefulness, and the free market and the law of the jungle should prevail. and all of them have strongly expressed views to me about one section or another that's coming up. I thought, Susan, that what you were going to use the copyright example as is one in which, if the point of restatements is to restate common law, why are we contemplating a restatement of a law that is not only largely statutory, but is, under the Constitution, a federal uniform statutory regime? And I have asked this question. I'm
Well, that was
smiling at your faithful member, but also Deputy Director Stephanie Middleton, because she knows that this is a question that I have asked repeatedly.
Well, this is the point of Jane Ginsburg.
Yes,
yeah.
and I have to say that that view has been strongly expressed by Jane Ginsburg, and I found myself quite persuaded by that. I don't think that any aspect of the copyright project is close to being decided, except that the council has encouraged the reporters and the advisors to continue working to try and come up with the best that they can. But I expressed this view and my and how persuasively I thought Professor Ginsburg's point was, and then sat and listened to Pierre Laval, who is not only an amazing academic and scholar and judge, but also really the father of the fair use doctrine, get up and give a very passionate and, to my mind, persuasive argument about why a restatement in this area was necessary, because although there are provisions of the Copyright Act that are highly reticulated and specific, and as to which obviously there's no need to restate anything other than reminding the reader that there is a federal statute on this point, there are large areas of copyright law, and fair use is as good an example as any, that are utterly common law.
Judge-made.
Yes.
Yeah.
Just as you can say that the Constitution is the super statute and the supreme law of the land, but it's expressed properly at a level of generality that has generated a very great body of case law interpreting what those words mean.
Seth, your other panelists are going to revolt shortly.
Okay,
So,
all right, never mind. I'll save any comments about
and we want to save a few minutes.
Section
questions
1902
or-
that that Ed identified for, if anybody has any questions about it.
Judge, I'll be very
Victor.
brief.
No, it's okay. Get in there.
I don't want anyone in the room to go away without appreciating a difference of view. I have no problem, nor did Herbert Goodrich or Professor Wexler, with the ALI and restatements taking a minority view, meaning that 30 cases go one way, 10 go another, and there's a trend in the 10. The reporters are supposed to state with clear and convincing words as to why they selected it. That has not always been done. It has been done sometimes. A perfect example would be the restatement of law of torts, economic harms, which was voted upon in 2017. Dean Farnsworth of Texas did everything a good reporter should do. So I don't want to say that that doesn't happen. But what I'm talking about are parts of restatements that have no law. It's not majority and minority. One section of the restatement of the law of liability insurance, section 27, the reporters only cited a dissenting opinion. You can look it up. That's it. So those type of things, with all the scrutiny, get through. And if that continues and that grows, 5 years from now, there will be more Justice Scalias looking to ALI products with skeptical views. I just wanted to share that with you.
John, what's your thought? Do you have a rebuttal to Seth or a comment?
Not in the specifics, because I have not attended ALI meetings. I would simply say what we've heard is, I think, an affirmation of what can happen in even the best and most careful institutions. That over time, as the work product grows, the number of restatements grow, some of them perhaps not absolutely necessary, people lead busy lives. And the people who have time on their hands, the theory of the leisure class, and I'm saying law professors, takes over. And the people who have the time to drill down and sit through endless meetings and formulate these and create this aspirational body of law in some of these restatements grows. And what I've heard from judges and what I've heard from some dissident law professors frequently is the number of people who used to be participating in this in greater number, consumers, government officials, regulators, people with direct knowledge of how the law operates on the ground, shrinks. So it's a natural tendency in every institution for these kind of things to happen. So I'm not saying the ALI this is unique to the ALI, but it has to be guarded against. It has to be discussed. These are natural tendencies that happen over time. And with something as important as the ALI, it's even more important that these be addressed before we get to the point that Victor mentioned, where we wake up someday and say, what in the world is going on?
In that regard, one of the things that I brought some applications for ALI in case anybody would like to apply. One of the things that I have observed, and I think it's easy for anybody to observe by looking at the composition of the members, is one, it's getting older. And I think that's something the ALI has tried to address by expanding the number of topics so that people at least can get into something that they can sink their teeth in a track. So if you're going to be a new member, what can you do? So there are more projects basically for them to be involved with. But the second thing is that there are fewer, I think, people of conservative lawyers of whatever variety, whether you want to say from one end to the other within the conservative spectrum. There are far fewer of them involved in ALI, particularly in the academic area, and that's self-evident by how people become academics in the country at large, a different topic. But my view about these things is if you care and you want to make an impact, join, get in there, and have something to say. So with that, I think we have, yes.
I just have a quick question for Seth or Victor. In the particular case of this restatement of the law on children in the law, an existing member who was dissatisfied with this sent me the draft. I cannot get this online. These things are kept, from what I can tell, they're kept protected, members only, maybe as some sort of benefit, but it hardly helps the interest in having real debate about them, to have early examination, to find problems if these things are kept hidden from other interested people.
Well, that is true, but the way to solve that is join.
The way to solve that is to put it on their website.
Well, I don't.
I mean,
that's-
again, Seth
I'm
said
not
you can-
arguing for or
yeah.
against that. I'm just saying there's one way to be involved in that, and I think maybe one. I don't have any idea why they don't do that. Seth, do you know?
I mean, I don't even know that they aren't. I would defer to Stephanie, who definitely has the answer to this.
Yeah, I'd be interested if I
And it may be that it depends, we're talking about stages of a process,
Right.
as I said at the outset, that can
Right.
go on 10 years or
Right.
more. And it may very well be that the initial preliminary draft of a subsection of the statement that's going to the council for first discussion and reversion back to the advisors and the reporters are not widely available. But Stephanie, what's the answer?
Well, so it's as you say, it's mixed, but for the consumer contracts project, we put that on the website. It was available to the public because it was of great interest. So, but we have copyright issues. The way the ALI stays alive is selling the restatements, and so we don't make it available completely to the world.
There we have
But
it.
you don't sell the drafts, so you can make those available.
We do sell the drafts, actually. We
Oh.
sell the-
Oh my God, are you kidding?
We sell the later drafts.
The early drafts you don't. Yeah.
The early drafts are, again, there are a lot of problems with the early drafts. Ed, you identified some, and they were discussed at the meeting, and the reporters are fixing them. And we appreciate comments from people like you who read it carefully. And I know a member sent it to you, but the mid to late drafts are available on the website, some for sale. Sometimes we put it out there for free, but we're not trying to be secretive, but we also don't want people to have their hair on fire about some of the early drafts, which clearly have lots of problems, and that's why it takes 10 years.
Look, I'll just make a modest suggestion. You know, we have an ever-growing philanthropic body in this country. We have multi-billionaires now who have more money than they know what to do with in their foundations. I think it would be a great trade-off if we have more transparency with the ALI by simply going to these foundations that are now sitting on hundreds of billions of dollars and saying, will you help us create a new business model so we don't have to pinch pennies and sell these drafts online? Let's make it available to everyone.
Okay,
And just
with
very
that,
brief- very-
I'll
briefly, if I
take
may.
your Rolodex with you. and
I
we
do have a Rolodex.
I know you do.
And just very briefly, in the particular instance I was talking about, this was a draft, but it was a draft that was going out to membership for a vote about a month later. And it sure seems to me that at that point, robust public debate might help inform your membership.
all right, I'm at point of privilege. I'm going to turn to the audience because we've got 10 minutes left, and I will be derelict in my duty if I don't. This gentleman first, and then you. I don't know if they have a microphone or if you even need one in this room. We do for the video. Okay.
We can hear Ed, no problem.
Thank you very much. I'm Edwin Williamson. I'm a retired Sullivan Cromwell partner. I finally got around to joining the ALI just a few years, either 2 or 3 years ago, in order to participate in the restatement of the fourth restatement of the law on foreign relations, because I had been the legal advisor of the State Department in the dark ages. But so when I went, and unfortunately that project did not cover anything very controversial, and it has gone through quite smoothly. But out of the corner of my eye, I caught this principles project on government ethics. And I must say, I think one of the good things about something like copyright, where there are real dollars involved, this government ethics does not seem to have much general interest. So I went to one meeting of lasted in March, of the advisory group and the member consulting group, which I'm in that latter part. And I was quite amazed at the lack of understanding of the body of law that we were discussing. For those of you who know much about government ethics, there are a few key concepts. Well, two advisory group members asked what the difference was between a particular matter and a specific party particular matter, which is huge. Another said, I find this phrase, personal and substantial participation in a particular matter or a specific one, kind of an awkward phrase. Why don't we use something else? These are phrases that are enshrined in a body of regulations about this thick under put out, under the supervision of the Office of Government Ethics. Now, they're not perfect, but at least it's something has been subjected to battle, comments, interpretations. People know how to work with them. I said, then these principles are now down to the point of they will not apply. Originally, they were going to apply to everybody. Judges, Congress, legislators, state legislators, the dog catcher. Now the judges have their own rules, and maybe Congress is a little different. We're not sure about state legislatures yet because they're suspect. But anyway, I think it is I think the thing is an amazing mess.
Thank you, Professor. Can you pass the...
That was a question, does everybody agree?
Brian Fitzpatrick, Vanderbilt Law School. I'm an ALI member, and I think, like everyone on the panel, I think it's an incredibly impressive and important organization, and I hope it continues its important work. But I, Seth, wanted to hear your answer to a specific assertion that Victor made, and that is, I understand that if different states have different rules, the ALI has to make a choice on what it puts in the black letter of the restatement, and sometimes that's going to be a minority rule. I understand that. But Victor says sometimes the ALI adopts in the black letter something that is not a majority rule, not a minority rule, but a rule adopted by no one. Do you think that it's ever appropriate for the ALI to put into the black letter a rule adopted by no one?
The way that you've stated it, all of the things being equal, which of course they are not, the answer is no. That is, this is meant to be a restatement that not only takes into account trends, the majority nose counting, but also, it is not part of your question, there may be rare instances in which there is a body of case law that takes into account not only that, it's not only a pure property case, but it's also a case that involves, and often involves, courts in discussions of trust law principles or eleemosynary responsibility principles or things like that. And if you'll recall, one of the third thing that the Institute members and reporters are meant to look at is evaluating what the rule is in light of corresponding but highly relevant bodies of law. It will be the rare instance, and it should be extraordinarily rare, where a rule is stated. I mean, it should never happen that it's made out of whole cloth. There has to be a provenance, either in existing case law or a persuasive case made by the reporters that, although the case law hasn't thought of it in this particular way, if you look at, with this particular rigor, if you look at the body of case law, that's what's going on. That is actually what happened with respect to the provision of law that was the subject of internecine dispute among the justices in Kansas versus Nebraska. There was no case in any court that had said, the way to answer this question is to take the following 3 steps. But there was general consensus that if you look at the rare instances in which this particular rule applies, that is, opportunistic, deliberate breaches, and you look at the way courts have decided it, this particular articulation actually reflects the thinking of most courts. So the answer is, it would be very, very unusual to find it, but I don't think it would be
I need a
impossible.
gavel here. We have a question here and one over here.
So here's a kind of tedious, pragmatic suggestion. Like many people in this room, I have to go through documents that I could never get through, except they're clearly marked for me, the changes that have been made or specific paragraphs to be read. Now, I am concerned about this idea that you get big drafts of rules, and the only way you find these troublesome provisions is you have to read and read and read and read. Who has time for that? Why don't you adopt a rule that when the drafts are sent around, if you're not following the majority rule, it has to be starred or marked in red. If you don't have any basis for what's being said, it has to be in bold and black. Somehow mark these items so you can just read that and then vote against it or discuss it at the meeting.
Seth?
And if you haven't marked it, then it would be a breach of professional responsibility.
Seth, you can take that back to the council. Sir.
All right, I'm Dimitri Karsid, professor of teaching torts and intellectual property at George Washington Law School. So I have a comment and a question. So comment is, first week of class on torts, I teach a parent agency, and I tell my students that the restatement formulation is actually the minority rule, and the majority rule, so the 3-step test, is not adopted in a restatement, and sort of teach the politics of that. So maybe as law professors, we should be doing that a lot. The question I have is actually about the ALI consumer contracts as an example. Once the draft became public, state attorney generals weighed in, Elizabeth Warren weighed in, and the vote was held off on the ALI consumer contracts restatement. And my question to the panel is it a healthy process? Is it a sign of what is wrong? Should it be happening more? Should it go online maybe sooner? Pache, copyright concerns and so on. But to me, it was sort of an example of public choice. You know, public does weigh in, and there was pressure on ALI.
I didn't know Elizabeth Warren was a member of ALI.
No, she weighed in as sort of
Oh, I see. Okay.
public, and the Attorney General sent in letters.
I did see the Attorney General stand and
Right.
talk at the meeting. Were very interesting, very persuasive. That was unusual. It was an event, shall we say. On this
There's a
side.
pragmatic answer, Professor. There were only 9 sections. So
Anybody
it
on
was
this
you
side
could
of
read
the
it.
room?
You could read it on the John.
Anybody else on this side of the room? Sir, and then we'll be concluded. Yes.
Thank you. So I apologize if this is duplicit, but my question is, ALI has taken a lot of criticism, especially on the consumer contracts restatement from both the left and the right. Is there anything it should do to rebuild its reputation?
Well, people disagree, but I think it should be made a principles project. In Section 6, you can void a contract based on deceptive practices. If you read what the reporters have, they're all Consumer Protection Acts. There's not one case there. In Section 9, they empower judges to impose a penalty against somebody who made a contract and decide whether they did or did not act in good faith and impose a penalty. That's not law anywhere. Again, that project began on the wrong road. It's no topic. There isn't a topic of consumer product contract. So they can have 14 years of correction. They're never going to get there. So it should be a principles project.
It was interesting that this turned out to be so spirited. But I appreciate everybody being here. I want to make a special note to thank Wesley Hodges of the staff, who has been very, very helpful in helping the panel prepare. And again, thanks to Dean Reuter and Leonard Leo for their leadership. And for all of you for coming. I will leave these ALI membership forms here if anybody wants them. Thank you.
So I'm genuinely interested in any response.
Thank you.
Great job.
Yes, I mean, I have a